On the morning, September 19th, 2025, Oconee County Emergency Services responded to a 911 call reporting an unresponsive child at a home on Forest Acres Circle. Paramedics and law enforcement arrived to find 4-year-old Isaiah Joseph Dionne already deceased. Immediate observations raised intense suspicion. The boy's body showed stark signs of malnutrition. He weighed only 21 pounds. He had sunken eyes, and his ribs and bones were prominent, indicating chronic starvation rather than a sudden event. Emergency personnel notified the coroner's office. This prompted an autopsy that would prove crucial for subsequent legal action. The case was then taken up by the South Carolina Law Enforcement Division, known as SLED. They opened a homicide investigation that same day. Now, in regards to Isaiah's domestic circumstances, the question is, how did this happen? His home environment was detailed in court documents and news coverage. It was described as severely neglectful, bordering on torture. Investigators alleged that Isaiah had been forced to drink water from a toilet and made to sleep in a closet, suffering brutal conditions alongside his younger siblings. Yes, there were times he was forced to drink the toilet water and to sleep in the toilet, as well as the closet. His other sibling was a 2-year-old who was subsequently placed in foster care. Only Isaiah showed signs of deprivation. The younger child was reportedly healthy. These appalling living conditions went unchecked by authorities or community members, which allowed the neglect to progress to lethal consequences. The autopsy of Isaiah Joseph Dionne told a tragic medical story. SLED reported the boy's weight as drastically below normal for his age. A healthy 4-year-old is between 30 and 40 pounds. Isaiah was a full 9 to 19 pounds underweight. Aside from the pronounced emaciation, the examination medical team cited chronic malnutrition, dehydration, sunken eyes, exposed rib bones, and general failure to thrive. These findings were pivotal in establishing not only neglect, but a fatal disregard for the child's welfare. So the question is, who put the child in this situation? Well, this brings us on to our suspects. Muppet number 1 is the mother, Destiny Dionne. She was 24. And Muppet number 2 is the stepfather, Joshua Emmanuel Latimer. They were immediately taken into custody. Both were initially charged with 2 counts of unlawful conduct toward a child. And as the investigation proceeded and autopsy results became available, prosecutors escalated the charges to homicide by child mistreatment under circumstances manifesting an extreme indifference to life. Now, this charge in South Carolina carries a mandatory minimum of 20 years in prison and can result in life imprisonment if the defendants are convicted. But it gets a little bit worse. Latimer drew additional media scrutiny because he was part of the South Carolina Highway Patrol Trooper. So sometimes when you're driving and you got to see you next Tuesday trying to pull you over on the highway? Well, he was one of those. And because of this, because of his arrest, his employer terminated his position shortly after, further fueling public outrage over a law enforcement officer's role in the crime. Both Dionne and Latimer are held in the Oconee County Detention Center without bond, where their trials set to be prosecuted soon. Now, I'm just quickly going to go over the timeline of events. So, September 19th, 2025, emergency services responded to the home. Isaiah is found deceased. September 20th, 2025, the autopsy is done. They ruled it a homicide. Then, a few days later, September 22nd-ish, Dionne and Latimer are arrested, charged with unlawful conduct toward the child. September 22nd, 2025, the charges are upgraded to homicide by child mistreatment. And in the following weeks, details unveiled in court and public record, including detail of Isaiah's prolonged suffering, forced deprivation, and neglect by those responsible, were all made public. And there's a lot more that we don't know because the case is still ongoing, and we probably won't know more for another 2 years till conviction. But as of late 2025, Destiny and Latimer remain in pretrial detention, facing a lifetime behind bars if convicted. The younger child is in protective custody, and ongoing legal proceedings are attracting close community and media attention. And of course, hopefully, the ultimate outcome of this case will likely influence policies on child welfare and law enforcement accountability for years to come. Essentially, Muppet A and Muppet B starved this child. We don't know why yet, but you know why I think? Because they're just a bunch of lazy bastards. I'm going to come on to another case shortly, but in a lot of cases, the stepfather, a lot of the times, is culpable because he doesn't see that child as his. So he doesn't have that same level of responsibility, which is bullshit because all children are our responsibility. So, on to my next case, you have Jessica, a 39-year-old woman from Pennsylvania. She was arrested and charged in 2025 after the shocking discovery of the remains of 4 newborn infants in her home. Yes, they went into her house, they found 4 newborns buried. The bodies were found by her former landlord September 13th, 2025, while cleaning out the property after evicting Jessica in August. The landlord discovered an infant's body wrapped in towels in a closet, and later, police found 3 more infants stored in tote bags in the attic, all concealed by Jessica over a span of 6 years. The grim discovery began when the landlord cleaning the vacant rented property on Oak Avenue detected a foul smell emanating from a closet. Now, inside a trash bag, he found the decomposed remains of a newborn, and after police were contacted, the state police conducted a thorough search of the home, uncovering the bodies of 3 additional infants hidden in plastic bags and wrapped in towels in the attic. This disturbing crime scene sparked a homicide investigation led by the Armstrong County District Attorney's Office. And during interviews, Jessica admitted to giving birth to 4 infants in the house over the past 6 years. She described traumatic instances of childbirth without medical assistance. In one case, about 6 years earlier, she gave birth in the bathroom, heard the baby whimper, then passed out on the floor. Upon regaining consciousness, she found the baby was unresponsive. She then wrapped the newborn's body in towels and concealed it in the attic. In another incident, about a year before her arrest, she gave birth again while sitting on a toilet and held the newborn wrapped in a towel until it stopped breathing. She then hid the body in plastic towels. Jessica, just go to a hospital. She reportedly did not seek medical care for any of the births, and no deaths were ever reported to authorities. This raised questions about her mental state and the conditions leading to these tragic events. She has 2 surviving sons, aged 6 and 8, who were cared for by neighborhood families and had no knowledge of their mother's pregnancies. Her husband, currently incarcerated, was not charged in this case. What does that mean? If her husband's in prison, who was getting her pregnant? Jessica faces multiple serious charges, including 1 count of criminal homicide for the death about 1 year prior, 1 count of involuntary manslaughter for the death 6 years prior, 4 counts of concealing the death of a child, 4 counts of mistreatment of a corpse. She has been denied bail and awaits further court proceedings. Her defense has contested some charges. I don't know where you get the bollocks from to contest them, but fair play. Suggesting that Jessica may have been in a dissociative or altered mental state during childbirth episodes. That could be the case. But prosecutors have presented compelling evidence tied to the concealment and deaths of the newborns. So authorities are continuing to investigate the case, including reviewing Jessica's medical history and conducting interviews with friends, co-workers, and her incarcerated husband. Autopsy results confirmed the presence of the 4 infants, but the exact causes continue to be explored. A preliminary court hearing was scheduled soon after the arrest, with further hearings and trial preparations underway. Maybe she was sleeping around, and then she was ashamed to tell her husband or something, and then she just acted like this. But then to do it over and over again, maybe there's a mental issue. We'll find out as the trial comes to light. Now my next story. Genesis Araya Matter. She was an 8-year-old girl from Bakersfield, California. She died in August 2025, but revealed harrowing details of sustained mistreatment and torture at the hands of her father, Ray Matter, and her stepmother, Graciela Bustamante. What is it with these step-parents, eh? The case stands out not only for the brutality endured by Genesis, but also for the criticism leveled at the CPS for failure to intervene despite numerous reports over the years. The discovery occurred August 2nd, 2025, at a La Quinta Inn motel in Bakersfield when police responded to a 911 call. There was an unresponsive child in the bathroom. Genesis was found dead in the bathtub, showing severe physical trauma. She had been subjected to repeated acts of violence, including marks from scalding hot water, whipping with wires and hangers, crushing injuries to her fingers that caused the nails to separate from her hands. Let me say that again, causing her nails to separate from her hands. What the fuck were you doing? She also had massive blisters and scarring across her body and face. Her injuries were consistent with prolonged and systematic torture. Now, following the investigation, Ray Matter, who was 31, and Graciela Bustamante, aged 27, were arrested and face multiple felony charges. These include first-degree murder, willful cruelty to a child, torture, aggravated mayhem, which refers to intentional disfigurement of a body part, child cruelty, conspiracy, and failure to provide necessary child care. During the police investigation, Bustamante admitted to pouring hot water on Genesis in an attempt to make her listen better. A child listening is not worth that much, you fucking moron. Graciela acknowledged witnessing Matter physically assaulting the child, including fisting and suffocating her. She claimed the mistreatment was motivated by frustration because Genesis would not obey. Both defendants initially blamed each other for the mistreatment and subsequent death, but eventually admitted to the participation in the violence. The couple's behavior was not isolated. They were also charged with child cruelty towards an 11-year-old boy in the household who bore signs of similar assaults. He had bruises, burns, and scarring consistent with ongoing mistreatment. This boy and 7 other children were taken into protective custody following the arrests. Now, this case drew community outrage, particularly because there were at least 20 documented reports to Kern County Child Protective Services about potential mistreatment in the household before the death. Family members and activists criticized the CPS for failing to protect Genesis despite numerous warnings. After her death, protests were held demanding accountability and better child protection enforcement. The CPS issued a statement expressing sorrow over the loss. Well, that's big of you, but cited ongoing investigations preventing detailed public comment. Genesis' family described her as a bright, loving child with a beautiful spirit who loved anything that sparkled and lit up a room. There were fundraising efforts to help cover funeral expenses and honor her memory within the community. Legally, Matter and Bustamante pled not guilty and are held in custody pending trial. If convicted, they face severe penalties, including life sentences or the death penalty. In summary, Genesis' death was the culmination of years of horrific mistreatment at the hands of her father and stepmother, who subjected her to sustained physical torture until her life was taken. And despite repeated reports to Child Protective Services, she was not rescued in time. Fingernails peeled off. Hot water. That's just disgusting. But let's move on to my next case. So, January 7th, 2008, in Alabama, 4 young children lost their lives in circumstances so horrific the case would become known as one of the most disturbing crimes in Alabama's history. Now, the children themselves, you had 4-month-old Danny Luong, 1-year-old Lindsay Luong, 2-year-old Hannah Luong, and 3-year-old Ryan Fan. Their father, Lam Luong, stood accused of driving his children to the top of the Dauphin Island Bridge and throwing each of them one by one into the waters 100 feet below. This is the story of that case. A story of tragedy, community grief, legal controversy, and questions about justice that will ultimately lead Alabama's Court of Criminal Appeals to overturn Luong's conviction and death sentence. But not because of his innocence, but because of serious errors in how this trial conducted. So, January 7th, 2008 began ordinarily enough. That morning at 10 a.m., Lam visited the nail salon where his common-law wife, Q Fan, worked. He asked her for money. she gave him $30 so he could buy gas for their van. This would be the last normal interaction they would have. Throughout the day, Q tried repeatedly to reach Luong by phone, but her calls were unanswered. Finally, around 7 p.m. that evening, she managed to speak with him. His explanation for where the children seemed strange. He told her he had left them with somebody else, a woman named Kim. Concerned and confused, Q and Lam reported the children missing to police that night. The next morning, the couple went to the police station where they were questioned separately. It was then Q asked if she could speak with Lam alone. In that conversation, Lam told her the devastating truth: the children were all dead. He had thrown them off a bridge and he would take police to show them where. Now, what followed was a massive search effort that would grip the mobile community for weeks. The children's bodies had been thrown from the highest point of the bridge into the swift waters below. The currents carried them in different directions, making recovery efforts extraordinarily difficult. Danny's body was discovered January 12th, approximately 12 miles from the bridge. Ryan's body was found the next day, 16 miles from the bridge. Lindsay's body was recovered approximately 18 miles from the bridge, and Hannah's body wasn't found until later. She traveled the furthest, approximately 150 miles from the bridge, all the way to Louisiana. The medical examiner determined all four children were alive when they were thrown. Danny, Ryan, and Lindsay died from blunt force trauma, combined with asphyxia due to drowning. Hannah died was just drowning. So the question is, what made Lam do this? Well, let's take a look at his background. He was born in 1970 in Vietnam. His birth was the result of a brief relationship between a black American serviceman serving in the war and his Vietnamese mother. In Vietnamese society, Amerasian children, especially black Amerasians, faced severe discrimination and were often ostracized from society. After his birth, Lam was given to his grandparents to raise in the countryside, away from Saigon. He remained with them until he was 9, when he joined his mother and stepsister and a stepfather in Saigon. When he was around 14, he came to America under the Unaccompanied Minor program run by Catholic Charities. He lived with the family in New Jersey. He attended high school in the United States through the 11th grade and held various jobs. However, he also developed a serious drug problem. He had a 1997 conviction for possession of cocaine and was sentenced to 3 years. He was charged again in 2000 with possession of cocaine. According to relatives and community members, he was described as a desperate crack addict given to bouts of violent anger. Now, his wife, Q Fan, was already pregnant when she met Lam, but Lam became the biological father of Danny, Lindsay, and Hannah. According to testimony, his drug problems and violent behavior were getting worse, and he did mistreat the kids all the time. He was getting fed up with the kids, and he would always hit them. Now, in February 2008, a Mobile County grand jury returned an indictment charging Lam with 5 counts of capital murder. The murders qualified as capital offenses under Alabama law. But the case immediately attracted intense media attention. The Mobile Press Register, the local newspaper, published articles about the case nearly every day, with many days featuring 3 or more articles. Local television stations aired hundreds of news segments about the murders. The coverage was extensive and in many cases inflammatory. Articles reported that Lam had confessed to the murders, that he committed them as an act of revenge against his wife, details of his criminal history and drug addiction, and even that Luong had said he wanted this case to be more famous than September 11th. The community's involvement in this case was unprecedented. Over 150 volunteers helped search for the children's bodies. A local cemetery donated burial plots for the children and set aside an additional plot for their mother. A local school raised money for Q. A permanent memorial was erected nearby in honor of the children. The community was invited to the graveside service, and a moment of silence was observed. And of course, the public anger toward Lam Luong was palpable. The newspapers had more and more sections regarding him. They were filled with comments about what punishment Luong deserved. In fact, one online forum, the topic was titled, "How Should the Baby Killer Be Dealt With?" It was viewed over 16,000 times. And remember, for 2008, that was a lot. A telephone call conducted in January 2009 of 350 people in the area, 84% of them had heard about the case, 44% had heard a lot about the case, and 71% had a personal opinion that he was guilty, and 75% thought other people viewed Long as guilty as well. Why is that important? Well, it played into the jury. So on March 5th, 2009, 4 days before his trial, he indicated he wished to plead guilty. The circuit court conducted a colloquy with Lamb about the ramifications of his guilty plea. However, on the day of the trial, he changed his mind when the court again went over the ramifications of pleading guilty. Lamb asked why the process was so complicated if he was pleading guilty. He said he had been told by a fellow prisoner at the jail that the proceedings would be over if he pleaded guilty. He then indicated he wished to withdraw his guilty plea, and the court allowed him to do so. This development created another wave of prejudicial publicity. Defense counsel argued that the publicity surrounding the guilty plea and his decision to withdraw it made it impossible to get a fair jury. And that was the point they were making. Newspaper articles, online forums, everyone knew about it and everyone thought he was guilty. Could he really get a fair trial? You could argue he didn't deserve one, and that's fair, but the law is the law. However, the circuit court noted he had caused this publicity himself through his own actions, an application of what's known as the invited error rule. It's an excellent point. You did this, bitch. Live with the consequences. So, following a jury trial, he was convicted of all 5 counts of capital murder. The jury unanimously recommended he sentenced to death by vote of 12-0. The circuit court accepted the jury's recommendation and sentenced him to death for 5 capital murder convictions. During the trial, the state's evidence included his confession to police, testimony from his wife about the events of the day, and testimony from the medical examiner about the causes of death. The state also presented a controversial videotaped experiment during the penalty phase. Now, this video showed police throwing sandbags over the bridge to show the impact the children faced. This was to demonstrate how hard the children suffered. So, Lam Luong appealed to the Alabama Court of Criminal Appeals. Eventually, they overturned his conviction. This was because of all the pretrial publicity. The most significant issue was whether he could receive a fair trial in the county, given the extensive and inflammatory pretrial publicity. He had filed a motion for a change of venue, arguing that the saturation of publicity made it impossible to see an impartial jury. The appeals court found that this case represented one of those rare instances where prejudice must be presumed. The court noted several critical factors. First, while Mobile County had a population of 500,000, making it larger than small communities in some famous prejudicial publicity cases, the nature and extent of the media coverage was extraordinary. The press register reached 81% of adults in the area, and local television stations aired hundreds of stories about the case. Second, the publicity wasn't just extensive, it was inflammatory. It included details of his confession, his criminal history, his drug addiction, speculation about his motives, and extensive community commentary about what his punishment should be. This went far beyond simple factual reporting of the charges and court proceedings. The community involved was unprecedented. The level was unprecedented. The court noted what distinguished this case from the average case was not only the extensive and pervasive publicity, but also the public's involvement in all aspects of the case, from efforts to recover the victims to opinions on the punishment. In fact, there was another case in Utah where a father was charged with throwing his infant into the river. In that case, the Utah Supreme Court found the widespread community effort to locate the child touched many adults and brought many people much closer to the crime than ordinarily occurs. The court concluded that community involvement accentuated the difficulty in seating a jury that was impartial. And in the case of Lam Luong, of the 154 prospective jurors who completed questionnaires, 139 of them heard of the case. That's over 90%. Most of them knew that he confessed to the murders or pled guilty. All 12 jurors who ultimately served on his jury had heard or read about the case, and 7 indicated they had heard he had confessed or pled guilty. Despite this, the circuit court only asked a few general questions. Finally, the court also addressed several other issues that were relevant to any retrial. The circuit court had denied the defense's counsel request for $7,000. What the defense wanted to do was go over to Vietnam, visit his difficult childhood, and gather mitigation evidence for the penalty phase. This, according to the appeals court, was an error. They should have been allowed to go, noting that given the severity of the potential punishment, which was the death penalty, it was reasonable and prudent for counsel to request funds to investigate the suspect's background, particularly given the discrimination and hardship he faced back home. And during the penalty phase, the state introduced the sandbag experiment I mentioned. However, while they were showing this experiment of getting a sandbag, throwing it off the bridge, and trying to demonstrate to the jury the barbaric nature of how the children died, there were no experts to verify any of this. No experts in physics or anything of that nature. The police captain who conducted the experiment was not qualified to testify about matters of physics and velocity. So, with all of this, his conviction was overturned and he was sentenced to life in prison. This case can only be put down to mental health. What do you think? Now I'm going to go on to my final case. No more children involved. This case is just straight up dumb shit. And when I think of dumb shit, I think of back home. We're going to the UK. So on September 22nd, 2025, Alex Rose and Charles Pardo were convicted of the murders of William Burchard and Darren George. These were two young men who lost their lives in a terrifying chase that ended when they were deliberately rammed off an e-bike at high speed. So the question is, why did this happen? Well, the events that led to this began with a misunderstanding. Now, Alex Rose, he was 29 years old. He was a businessman. He believed his home was being targeted by a group of young men who were trespassing at the grounds of St. Paul's School. The school backed into his property, so essentially he thought someone was trying to rob his house. And this wasn't his first experience with crime. His business premises had been burgled earlier in the year, and when no arrests were made, he told police he would investigate the matter himself. This statement would prove prophetic. So rather than calling police when he suspected trespassers, he decided to take matters into his own hands. He recruited Charles Pardo, a 24-year-old who worked for him, to help search for the suspected intruders. What began as a search on foot quickly escalated when the two men got into a Ford Raptor pickup truck and continued their hunt. So they get into this van, and for about an hour, Rose and Pardo worked together. Pardo had multiple opportunities to leave, but he chose to remain with Rose and actively participate in the continued search by road. So these two muppets got into the van, driving around and around and around, trying to find kids maybe, who may have trespassed. So as they were driving, Rose and Pardo spotted William and Darren George riding on Burchard's e-bike. They made an assumption these were the culprits they'd been searching for. In reality, Burchard and George had nothing to do with that group, the group that had been on the school grounds adjacent to the house. They were simply two young men going about their evening completely innocent of any wrongdoing. The two victims were traveling at a normal pace, in no particular hurry, until Rose accelerated his powerful pickup truck behind them. Sensing danger, William Burchard sped up, trying desperately to escape the vehicle pursuing them. The e-bike veered across the wrong side of the road, at one point as Burchard attempted to evade his pursuers. Rose chased them at speeds of around twice the speed limit, a terrifying pursuit that would end at the Sunbury Cross roundabout. In a desperate attempt to escape, William made the dangerous decision to navigate the roundabout the wrong way. But Rose was relentless, following very closely behind as Burchard rode across the slip road against the intended flow of traffic. The chase continued until Rose caught up with the e-bike and drove into the rear. So as he collided with the bike, both young men were thrown with tremendous force. The impact was so severe, William Burchard died immediately at the scene. His injuries were multiple fractures, abrasions, and he lost skin on his face, head, body and limbs. The medical evidence showed that a severe degree of force had been applied to the front of his head, causing fatal injuries to both the front and back of his brain. Darren George's fate was equally tragic. He suffered an accelerating fall and sustained multiple fractures and abrasions to his head, face, torso and limbs. Most critically, he suffered a brain injury. from which it was almost inevitable he would not survive. He did remain alive long enough to be taken to the hospital, where he was pronounced dead. Now, what happened after speaks volumes about the character of the men involved. Neither Rose nor Pardo stopped to check on the victims. They didn't get out of the vehicle, they didn't call for an ambulance. They showed not a shred of concern for the two young men. After driving Pardo back to where his van was parked near Rose's home, Pardo drove away and his route took him past the collision site. Even then, seeing the two young men still lying on the road, he did not stop to check or render aid. Meanwhile, Alex Rose embarked on a calculated mission to evade justice. He parked his Ford Raptor away from his house and walked home. He then falsely reported that his vehicle was stolen. This false report would form the basis of an additional charge, the charge of perverting the course of justice. But Rose's attempts to escape accountability didn't end there. Over the next day, he tried gathering enough money to flee the UK. This is where Tara Nags entered the story. She was in a relationship with Alex, and when he needed help fleeing the country, she did not hesitate. The evidence presented at trial showed Tara was in telephone contact with Rose at the time of the collision, and she remained in close contact with him. Over the 2 days between the killings and their eventual arrests, Tara was instrumental in Rose's escape attempt. She booked hotel accommodation where they could lie low before heading to the airport. She made persistent and determined efforts to book flights out of the UK. She paid for taxi journeys away from Sudbury and to Birmingham, over 100 miles from their home. She allowed her bank accounts to be used to pay for flights. And when they were finally arrested, she was carrying £4,000 in cash in her luggage, along with a few personal items for herself and Rose. The evidence showed Tara maintained telephone contact with others who could facilitate Rose's escape and allowed Alex Rose to use her mobile telephone to coordinate his flight. She accompanied him on a journey to the south coast and then back to Oxford and finally to Birmingham Airport. They became remarkably close to succeeding, but then police arrested them 2 hours before their flight. While they were on the run, Alex Rose managed to dispose of his mobile phone and the keys to his truck, further hindering the police investigation. The investigation itself faced significant obstacles due to his false report and his disposal of evidence. Because Alex had claimed that his truck had been stolen in a burglary, police had to prove this wasn't the case in order to establish that he was the driver at the time. This necessitated forensic examination of both the home and the vehicle itself. Rose's false claim that the keys had been stolen, combined with his actual disposal of them, hindered the examination of the truck and its telematics system. This is technology in the car that could have provided crucial evidence about the vehicle's movements and speed. Despite these obstacles, the prosecution built a compelling case. They brought a collision expert who provided crucial testimony about the final moments of the chase. This expert described how the Ford Raptor was driven extremely close to the e-bike. In her expert opinion, the Raptor came up to the e-bike from behind and deliberately hit them, or at least pushed them against the curb. Now, the trial itself lasted several weeks, with the jury hearing evidence about the coordinated search, the high-speed chase, the deliberate ramming, and the subsequent cover-up and escape attempt. On September 9, 2025, the jury returned guilty verdicts for both Rose and Pardo on 2 counts of murder. Rose had already pleaded guilty to perverting the course of justice. Shortly before the jury was sworn, Tara was convicted of assisting an offender. Now, regarding the sentences, September 22, 2025, the judge handed down sentences that reflected the severity of the crimes and the aggravated factors present in the case. Tara was convicted of assisting an offender. The maximum sentence is 10 years, and the judge found that Tara was aware of the seriousness of Rose's offending. She was instrumental in helping him to flee the country. The judge, in his mind, he was thinking, "You have misguided loyalty, but nonetheless, you are loyal to a criminal." She was sentenced to 3 years. For Alex Rose and Charles Pardo, they were convicted of 2 counts of murder, and the only sentence prescribed by law was life in prison. But it wasn't that straightforward. How long is life in prison? Now, for Alex Rose, the judge found him particularly high culpability. The judge was satisfied that Rose's mindset as he searched for the supposed burglars was to effect retribution. The evidence showed he took his vehicle to the scene with the intention of using it as a weapon, or at least having it available as a weapon. The judge noted that the victims were vulnerable road users on an e-bike without protection for their heads, a fact that must have been obvious to Rose when he deliberately rammed into them. Rose also received a separate sentence for perverting the course of justice, while his false report came after the vehicle had already been found by police. His disposal of the keys hindered examination of the vehicle's telematics system. For this offense, he received 21 additional months. Rose, however, had no previous convictions, and letters from prison staff and friends attested to his positive behavior in custody. However, these factors could not significantly reduce the sentence given the severity of the crime. Alex Rose was sentenced to life in prison with a minimum term of 34 years. He must serve 32 before being eligible for parole. Charles Pardo himself had previous convictions, including one for dangerous driving, and though the judge noted he had no previous convictions for violence or weapons offenses, he was still a big player in this crime. He was sentenced to life in prison with a minimum term of 29 years. All of this over, what do you want to call it, misunderstanding? He got the wrong people. They were driving around like two idiots, found a random person and thought, he's the one that tried to burgle my house. How fucking stupid could you be? You know? But why don't you comment? Tell me what you think.